Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. The FTC's non-compete ban did not go into effect today. That's thanks to a Texas District Court decision last month. The decision banned the FTC rule on a nationwide basis and ordered that the rule should not be enforced or otherwise take effect on September 4th. So restrictive covenants are still valid for now. But how long will that last? Epstein Becker Green's Pete Steinmeier is here to tell us more and offer a look ahead.
Pending further developments from the courts, employers need not comply with the FTC's rule, and they need not send out the notices that they were otherwise required to send out on September 4th. The court decision has no direct impact on the other two cases that are currently challenging the rule. Nevertheless, it's unclear, given this ruling, whether the plaintiffs in those other two cases will continue to fight those cases or drop them.
While this decision gives employers reprieve in the immediate future, the long-term outlook for non-competes is still grim.
We expect that state legislators will continue to enact laws restricting the enforceability of traditional non-competes, especially for middle or lower wage workers. Employers should therefore remain cautious of using traditional non-competes and keep abreast of new laws in jurisdictions where they operate. EBG's 50-state non-compete survey, which is available for free on our website, is one great way for employers to stay abreast of these legal developments. Employers may also want to take a moment to think holistically about their entire approach to protecting their trade secrets and customer and employee relationships. Traditional non-competes can be an effective tool, but they are just one of many tools. Other tools, which are far less likely to be challenged in the courts, include garden leave provisions, confidentiality agreements, customer non-solicitation provisions, trade secret audits, and trade secret training programs. Finally, when it comes to protecting trade secrets, employers should not overlook the importance of having a meaningful exit interview process.
Thanks, Pete. Visit ebglaw.com/50state to find that 50-state non-compete survey tool. And thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.